heavily contested this ingredient and insisted that the accused person was not in a right state of mind to form an intention to commit the offense of murder.
Nti oludda olw'omuwawaabirwa balooya be bagamba nti ebyo si bituufu kubanga nti omuwawaabirwa omutwe gwe gwali tegukola bulungi n'olwekyo yali tasobola kutemula.
The accused person in his unsworn statement stated that he did not act intentionally or deliberately, and although there were claims that he was completely mentally okay, there may have been other mental challenges that may have gone undetected, which could have contributed to the death of the children. He insisted he was not mentally okay.
Nti bwe yali ayewozaako teyalayira naye n'agamba nti ye kino teyakikola mu bugenderere, n'agamba wadde nti bagamba nti omutwe gwe gwali gukola bulungi naye bayinza okubawo ebintu ebirala bye bataategeera ebiyinza okuba nga byamuviirako okukola ebyo bye yakola, n'akkakkatizza ensonga egamba nti ye omutwe gwe tegukola bulungi. Omutwe gwe gwali tegukola bulungi.
The accused also denied being foul-minded in the killing of the children, and in respect to this, he made reference to the book. I already talked about that, but this is for emphasis. That the flash disk which showed that he had done a search and saved a book on the art of war. He stated that he did it long ago and it had nothing to do with the death of the children.
Nti era agamba nti ekino ekintu kyonna teyakiteekateeka ekyokutta abaana, n'agamba nti ekyokuteeka akatabo k'entalo n'okunoonyereza byonna bye yanoonyereza, agamba nti akatabo yakanoonyerezako ebiseera by'emabega nnyo tebiyinza okuba nga byo byamuviirako okutta abaana abo.
He also denied being deliberate and with forethought while making reference to the evidence of the Google searches that he made using his phone, specifically the search for ISIS beheading and for schools that teach young children. And he said that whereas these searches may suggest that he did it deliberately, there were other factors forcing him to make those searches, which factors he chose not to disclose to the court.
Nti era yagamba nti ye teyabikola mu bugenderere, era n'agamba nti bino bye yanoonyerezaako ku mukutu ng'ebya ISIS okuggyako emitwe, amasomero agasomesa abaana abato, nti naye waliwo ebintu ebirala ebyamuleetera okunoonyereza ku bintu ebyo.
You have not also interpreted the factors. Those factors he did not disclose them to the court.
Nti ebintu ebirala ebyamuleetera okunoonyereza ku bintu ebyo teyabibuulira kooti.
The accused person further stated that he was under the control of some people whom he occasionally referred to as friends and were in three categories.
Nti yagamba nti yali akola olw'ensonga y'abantu be yali ayita mikwano gye ate nga baali bangeri busatu.
He also alluded to the fact that between January 2026 and March 2026, he entered into a distressing period because he was contending with some people who were surveilling him, making demands from him, and they threatened to kill him.
Nti yagamba nti wakati w'omwezi gwa January n'ogwokusatu 2026 yali mwenyamuvu nnyo olw'abantu be yali abaali bamusumbuwa era nga agamba abaali bamutambulirako era kyekyamuviirako okukola ebintu bino.
According to him, they began demanding for money, and he noticed that they had all the capabilities and they were following him closely. And as a result, he left the neighborhood of Bunga, where he was staying, and resorted to sleeping on the streets.
Nti baali bamusaba ssente era nga yalaba nga baali balina obusobozi nga bamugoberera nnyo, kyekyamuleetera kuva Bunga gye yali abeera n'agenda n'atandika kubeera ku luguudo.
The accused person stated that as a result of this, he tried to end it somewhere and somehow, so as to bring the whole thing to an end. And according to him, he tried to flee the country, tried to rob a bank, and tried to kill his brother's family. He then said that those people whom he at times referred to as his friends during his testimony had something to do with his actions of 2nd April 2026.
nti yatuuka ekiseera n'ayagala kikomenkereza n'asalawo ave mu ggwanga n'agezaako okubba banka n'agezaako okutta famire ya muganda we n'agamba nti abantu abo be baali balina kye balina ku kyatuukawo nga 2 Ogwokuna 2026.
He invited the court not to honor the charges of murder because there were some circumstances that forced him to act the way he did on 2nd of April.
N'asaba kooti ereme okumusingisa omusango ogw'obutemu ng'agamba waliwo ensonga ezamuleetera okukola bye yakola nga 2 Ogwokuna 2026.
Unfortunately, he neither stated the circumstances he claimed forced him to act that way, nor did he disclose the identities of his friends who may have compelled his actions on 2nd April 2026.
Ntebyembi teyayogera biki ebyamuleetera okukola ebintu ebyo bye yakola nga 2 Ogwokuna 2026.
No, he did not state the circumstances, and he also did not disclose the identities of those friends of his.
Nti ebintu ebyo ebyamuleetera okukola bye yakola ate n'amanya oba okwogera baani abamuleetera okukola ebyo bye yakola 2 Ogwokuna 2026 teyabyogera eri kooti.
And because he made an unsworn statement in his defense, he could not be probed to give more information.
Olw'ensonga nti teyalayira ng'awa obujulizi baali tebasobola kumubuuza ebibuuzo bingi ku kino.
By the above claim, the accused raised a defense of insanity.
Olw'ekyo yagamba nti ye omutwe gwe gwali tegukola bulungi mu kaseera ako.
The defense of insanity is provided for under Section 11 of the Penal Code Act, Chapter 128.
Nti ekyokugamba nti omuntu omutwe guba tegukola bulungi ekitabo kya bibonerezo kikyogerako mu kawayiro ka 11.
And this is what it provides: that a person is not criminally responsible for an act or omission if at the time of doing the act or making the omission, he or she is through any disease affecting his or her mind incapable of understanding what he or she is doing, or knowing that he or she ought not to do the act or omission, although his or her mind is affected by disease, if that disease does not in fact produce upon his or her mind one or other of the effects mentioned in this section in reference to that act or omission. I will summarize this to mean that the accused, somebody must show that he had a disease of the mind, and as a result of the disease of the mind, he was incapable of knowing the nature and quality of his actions at the time when that action is said to have been done. That's the summary of this law.
Nti etteeka lino mu bufunze ligamba nti omuntu alina okukakasa nti yali alina obulwadde bw'obwongo, nti ate okubeera n'obulwadde obwo nti yali tasobola kumanya ebikolwa bye yali akola kye bitegeeza oba kiyinza okumuviira mu bikolwa by'akoze.
So if it is found that actually he had a disease of mind, and that disease of mind made him incapable of understanding what he was doing and what its consequences would be, that would be a total defense to him.
Nti bw'agamba nti yali alina obulwadde bw'obwongo nga tasobola kutegeera biki bye yali akola, awo aba yeewozezaako.
And for the offense of insanity to stand, the accused person must satisfy the ground set out under the Magnaten rule, and the test is purely cognitive, and the defense must show whether the accused understood his or her actions or that his or her actions were wrong. The defense of insanity is twofold. First, that an insane defendant does not have control over his or her conduct, similar to somebody who is sleepwalking, not knowing what they're doing. And secondly, that the defendant does not have the ability to form a criminal intent. Without the ability to control conduct or the understanding that conduct is evil or wrong by society standards, an insane person or defendant presumably will commit crimes again and again. This person must not be in control of anything to do with himself. He cannot control his actions because of the disease of the mind. These rules require that the three tests should be proved. One, that an individual suffers from a defect of reason, which is caused by a disease of the mind, and that as a result, he or she does not know the nature and quality of his act, or that that act is wrong. And when somebody raises a defense of insanity, when he says was not normal, like the accused person said that was not mentally okay, then it becomes his responsibility to prove to the court that actually that was the condition that he was in at the time the offense was committed.
Nti omuntu okugamba nti omutwe gwe gwali tegukola bulungi alina okukakasa kooti nti yali tasobola kutegeera ebintu byali akola oba byali bituufu oba byali bikyamu oba byali si bikyamu, nti alina okulaga nti yali tamanyi biki byali bigenda mu maaso n'ebintu bye yali akola, abeera ng'omuntu atambula ekiro nga yeebase nga tategeera biki ebigenda mu maaso. N'agamba nti omuntu bw'atyo aba tasobola kubeera mu mutwe nga ateekateeka ekintu okukola ekintu ekikyamu kubanga aba tasobola kumanya ekikyamu oba ekituufu. N'agamba nti aba tasobola kwesalirawo biki by'akola olw'ensonga nti alina obulwadde bw'obwongo.
The defense of insanity seeks to do away with an essential requirement of malice aforethought, and it seeks to prove that the accused person did not have the intention to cause death, neither did he have knowledge that such an act or omission would cause the death. And this is because of the presumption of sanity which is provided for in Section 10 of the Penal Code Act.
Nti okugamba nti omuntu omutwe gwe gwali gulina obulwadde baba baagala okuggyako ekyokugamba nti omuntu yayanya ekigendererwa okutta abantu naye
there is a presumption of sanity.
Naye waliwo amateeka agagogera ku ky'omuntu okubeera nga omutwe gukola bulungi.
And it provides, in Section 10, it provides that every person is presumed to be of sound mind and to have been of sound mind at any time which comes in question until the contrary is proved.
Era etteeka kawayiro ka 10 kagamba nti buli muntu yenna bamutwala nti omutwe gwe gukola bulungi oba talina bulwadde bw'obwongo okutuusa nga baleese obujulizi okulaga nti mu butuufu omuntu oyo akaseera ako omutwe gwe gwali tegukola bulungi.
This presumption of sanity puts the burden on anyone who claims insanity as a defense to prove that he or she was not in the right mental state at the time of the act or omission.
Kino kiraga nti omuntu agamba nti omutwe gwe gwali mulwadde oba ng'alina obulwadde bw'obwongo alina okuleeta obujulizi okukakasa nti akaseera ako omutwe gwe gwali tegukola bulungi oba yali alina obulwadde bw'obwongo.
And I have already said that when anyone advances a defense of insanity, he bears the burden to prove it, though not on as a higher standard as the prosecution has to prove the case against him beyond reasonable doubt.
era nga bwe yagambye nti omuntu bw'agamba nti yalina obulwadde bw'obwongo yalina okuleeta obujulizi okukakasa nti mu butuufu yalina obulwadde bw'obwongo mu kaseera ako.
I have cited a number of cases which can be found in the judgment. Having laid down the above principles from the law and the decided cases, I will proceed to evaluate the evidence adduced by the accused person in a bid to prove the claim or the defense of insanity.
Amaze okutunuulira obujulizi bwonna agenda okutunuulira.
No, I have said having laid down the above principles from the law and the decided cases on the defense of insanity.
Oweekitiibwa Omulamuzi ng'amaze okwogera ku mateeka agakwata ku ky'obugamba nti omuntu omutwe gwe, amateeka n'emisango emirala egyayogerwako ku bulwadde bw'obwongo, kati agenda kutunuulira obujulizi bwe baleeta obukwata ku bulwadde bw'obwongo.